today to our Handling the Disciplinary Process virtual boardroom that's being facilitated by HR recruiter Nathan Andrews. My name's Jo Thompson. I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan will discuss things we should consider to help reduce risk for the organisation and good practice guidance to ensure a fair outcome for the employee. If you've any burning questions during the session, please put them into the chat box facility and we'll cover them as we go along. I'm now going to hand you over to Nathan, who will introduce himself and start the event. Thank you.
Thank you, Jo. Hi, good afternoon, everyone. As Jo said, my name is Nathan Andrews. I'm the Head of HR Services at Fretton's Solicitors. We provide a generous bank of HR services to our clients. I specialise in HR case management, conducting employee investigations and mediation and conflict resolution services. So today's webinar is going to be talking about handling the disciplinary process. I'm going to run through some of the basic steps that you need to consider when handling disciplinary issues. Some of the key concepts that we're going to discuss, or the key areas that we're going to focus on, will be the difference between disciplinary issues and grievances. We'll talk about the ACAS Code of Practice on discipline and grievance itself. We'll then talk about the difference between disciplinary rules and procedures. We'll then focus on the difference between misconduct and gross misconduct. We will cover dealing with particular issues through questions, so that will be part of the session. And then we'll talk about conducting a disciplinary hearing and reaching a decision before covering off the right to be accompanied and the appeal procedure. So in terms of the difference between disciplinary issues and grievances, this is a really important point that you need to bear in mind if you are an HR practitioner or indeed a line manager responsible for handling disciplinary issues in your organisation. So disciplinary issues arise when problems relating to conduct or performance are identified by you as an employer, and where you are looking to address your concerns through established policies and procedures. Those will typically be things like your disciplinary procedure and any other procedures you may have in place that would be relevant to the matters that you are handling in any specific case. Grievances, on the other hand, are raised by employees. These are typically complaints made by the employee that then need to be dealt with in line with your grievance procedure. So that is the key difference to bear in mind. So if we just touch on the ACAS Code of Practice on discipline and grievance, so both employers and employees should follow the ACAS Code of Practice on when they're handling discipline and grievance issues. The ACAS Code contains 4 sections, so if there are HR practitioners on the webinar, you'll be familiar with this. There's a foreword, which is purely advisory. Then there's the introduction, which sets out the general principles to all disciplinary and grievance matters for organisations to follow. And then there are 2 further sections dealing with disciplinary matters and then grievance matters respectively. And we always advise our clients to make sure that they pay attention to the ACAS Code on matters that they are handling in the workplace to ensure that they essentially follow a fair process. So this is a particularly important point. Again, if you have any questions, I'm not going to go into any more detail, and I'm also aware of time constraints essentially for the webinar, but if you've got questions at the end, then I'm more than happy to answer them. So what are disciplinary rules? So disciplinary rules should set out the standards required of all employees to which they apply. They should make clear to employees what is expected of them, and they should also set out the consequences of breaking the rules or failing to reach the required standards expected of them in their job role. I always advise clients that disciplinary rules should ideally be contractual terms, so that if an employee were to breach any disciplinary rule, it's essentially a breach of contract. That being said, and I will come into this in more detail, I don't suggest that your disciplinary procedures are contractual. I would advise that they are non-contractual so that you don't tie yourself up in knots, essentially, whereby you have to follow your procedure to the letter. Otherwise, you could face a potential breach of contract claim. So that's an important point to consider. Happy to take any questions on that later on. So just to cover off the difference between misconduct and gross misconduct. So misconduct is conduct which initially requires disciplinary action other than dismissal. So it's not so serious that it's damaged the mutual trust and confidence that needs to underpin the working relationship. That said, gross misconduct is what we would consider a deliberate or willful flouting of contractual terms or misconduct so serious that it renders the trust and confidence in the relationship to have been broken so sufficiently that it's essentially the working relationship is broken down irretrievably, that you can't repair it. So essentially, gross misconduct is misconduct that is so serious that you would lose trust and confidence in the individual, and therefore you would consider dismissing on those grounds. So it's really important that people understand the difference between misconduct and gross misconduct to ensure that any decisions made at the disciplinary stage are fair and reasonable in the circumstances. So just to come on to what are disciplinary procedures. So disciplinary procedures should be created to provide a framework for your line managers to follow when dealing with disciplinary issues, and they should help managers to deal with matters fairly and consistently when any disciplinary issue arises. I can't stress that enough. If you're handling disciplinary issues, it's really important that your line managers are acting fairly and consistently across the board when dealing with issues to avoid there being any risk of claims being brought against your organisation. As I said, it's absolutely advisable for the procedures to be non-contractual so that you can retain as much flexibility as possible when implementing your disciplinary procedures in practice. So I can't stress that enough. So in terms of conducting a disciplinary hearing, there are no set legal rules to be followed for disciplinary hearing itself, so how you conduct the hearing, but there are principles that you should follow. I always say a lot will depend on the particular circumstances of the matter that you're dealing with and whether you have set out any procedural guidelines, as we discussed earlier, such as rules and procedures. Ideally, you will have a disciplinary policy that will set out your rules and procedures within that policy document and make clear the contractual status of the document. Now, as I've said, there's nothing wrong with your disciplinary rules being contractual, but you don't want your disciplinary procedures to be contractual, and you need to be very clear in that regard. If you do have disciplinary policy that is contractual, just a point to bear in mind, it would therefore be essential that you follow that policy to the letter so that you avoid any risk, I should say, of a breach of contract claim. So you need to pay close attention to the contractual status of your policies when you are relying on them to take disciplinary action. But as we know, if you're conducting a disciplinary hearing, essentially you need to invite that employee in writing to attend that hearing. You need to set out the allegations that are going to be discussed with them at the hearing. You need to make available to them any evidence that you are going to rely on at the hearing, so that they have, and that needs to be done in advance of that hearing, so they have sufficient time to prepare their case. That's absolutely essential in the interest of natural justice. You don't want someone attending a hearing being unclear of the allegations that are being made against them, and not having sufficient time to review the evidence that you are going to rely on as the employer in terms of discussing and reviewing that during the hearing. So it's really important that you follow those steps. So absolutely write to the employee, invite them in person, and give them reasonable notice of the hearing itself, along with making copies of the evidence bundle available as well, and in good time. During the hearing, you want to obviously have an introduction. So you want to introduce all parties attending that hearing, so who the chairperson is, who the note taker is, and the role of the note taker. You also want to introduce any representative or companion that the employee chooses to bring with them if they choose to be accompanied. That's particularly important. And you should also look to cover off the remit of the role of a companion to make sure that person understands what they should and shouldn't do during the conduct of that hearing. Then you want to move into setting out the allegations being made against the individual, and you then want to go through and review the evidence carefully with them and ask for the individual to respond to those allegations and to give them sufficient time to set out their case and time to allow you to take into consideration any representations that they make during the course of the hearing. That is particularly important. So when it comes to the decision and outcome, so unless the case is particularly straightforward, the hearing should be adjourned before a decision is reached. I always advise that you should take an adjournment, typically 24 hours, depending on the complexity of the case. That does go some way to demonstrate that you've taken time to consider the responses and representations made by the respondent in the case that you are dealing with, and it shows that you've not made a knee-jerk decision or that you have had any predetermined outcome in mind when handling that particular case. So that's particularly important. I can't stress that enough. I advise clients on a regular basis to make sure that they do allow for a sufficient adjournment to ensure that they can demonstrate that they are giving proper time to consider responses and any counter evidence that the employee may wish to present when they're stating their case. The employee should be told about the result of any further investigations and should be given the opportunity to respond if that is relevant. So if you feel that there is missing information, you need to be setting that out to the employee. And if you are going to do further investigation, explain that to them. That's particularly important. If the facts are disputed, the manager conducting the hearing should decide which version is the most probable, bearing in mind that the burden of proof within employment matters is on the balance of probability. So what is reasonable for us to believe in the circumstances based on the evidence you have available to you. So that is a particular point that you need to bear in mind. So, do workers have the right to be accompanied at disciplinary hearings? I've already touched on this briefly, but yes, they absolutely do. Section 10 of the Employment Relations Act 99 provides for the right to be accompanied at formal disciplinary hearings by either a trade union representative or a fellow worker. That being said, I have dealt with situations whereby I may have an individual who has made a request for a friend or a relative to attend with them to support them. And that may be because they have certain health conditions, a disability, or even mental health challenges that they require particular support with, and that they believe that having a friend or a relative attend with them could be helpful in terms of supporting them to engage in the process meaningfully. I always take, each case on its own merits. If someone makes a particular request, I will consider that request. And if I can accommodate that request, I absolutely will, because I want to demonstrate that I'm being reasonable in the circumstances. That being said, you want to be mindful that you don't want to allow someone to attend who turns out to be an employment lawyer, for example, because that is not that does not fall within the description of a companion or a representative. So you need to be mindful about how you handle that situation. But I always say that if someone says, I need a friend, for example, to attend with me, and that will help me be able to engage meaningfully in the process, then I'm likely to allow that, because I would consider that to be a reasonable adjustment. But you need to take the circumstances into consideration when making a decision. And if you're uncertain about your position, take proper advice from your HR department, or if you're working with an external provider, contact them for further guidance. And then finally, we come on to the appeal procedure. Now, this is a particularly important part of the disciplinary procedure. Once you've made a decision on the outcome of a disciplinary procedure, you need to make sure that you offer the right of appeal, particularly when you've got an employee who has full employment rights. I don't necessarily automatically advise that you issue or you provide a right of appeal if you're dealing with a short-serving employee who has less than 2 years service currently, but soon will be 6 months. But if you've got an employee with full employment rights, then they are entitled to the right to appeal any disciplinary decision imposed upon them. And so it's important that you set that out in any letter confirming the outcome of the disciplinary hearing. So you make it very clear that they do have the right to appeal, who they should appeal to. It should be very clear that they must set out their grounds for appeal in writing, and you should set a timeline for that appeal to be submitted. I always recommend 5 working days. It could be calendar days, it depends on your organisation, but refer to your policy. If you do receive an appeal, it's important that you deal with that appeal in a timely manner. I always say that, offering the right to appeal is an opportunity, if there have been any procedural missteps, for you to essentially use the appeal process to mop up any issues that may arise, and ultimately to make decisions about the original sanction imposed and whether that was reasonable within the circumstances. So the appeal stage is very important, and it's something you should absolutely be mindful of when setting out your outcome letter to that individual. So I appreciate that was a whistle-stop tour of handling the disciplinary process, but we've kind of designed that deliberately because we normally get lots of questions. So I'm going to open up to questions, and hopefully, Joe, if you're there, you'll be able to. Thank you, Joe. I can't see, which is why I said that on my screen. But yeah, if we want to go through questions, then this is normally where we get lots of interaction.
Apologies, I thought you could see me.
No, it's my screen. It's my screen, Joe, not you.
Okay, fine. So yeah, we haven't got any questions in there at the minute, but normally we do have. So if anyone's got questions, please feel free to put them into the chat.
Yeah, please.
You've covered that really quick, Nathan.
It was. Well, I tried to keep, because I know normally sometimes these sessions can go on, a little bit. We don't have enough time for questions, but
It's because you're so used to doing them now.
Yes. Yeah, well, it's such an interesting topic. I mean, we're seeing a big uptick. So I don't know whether people are experiencing this themselves. We're seeing a big uptick in supporting clients with disciplinary matters. And actually, what I often see as a big challenge is organisations following a fair and reasonable disciplinary process. And so, we kind of do a lot of this training work with clients around making sure you follow a process. The disciplinary procedure itself doesn't have to be onerous, and actually it's quite, the operation of it in practice is very straightforward. But the challenge comes when you're dealing with particular issues, and obviously the complexity around those particular issues. So, it's an important practice that we need to be familiar with, and ultimately, going through that process in a methodical way helps mitigate, the risk of claims being brought against organisations. So I think that is particularly important.
Okay, there's a couple of bits just come in. So
yeah, perfect.
Katie's just said, to clarify, disciplinary policy should be contractual, but procedures should not.
No. So to be really clear, your overall policy shouldn't be contractual. What I would advise, you can do one of two things, but what I would say is your disciplinary rules, there's nothing wrong with those being contractual, because they're the rules that you want your employees to follow. And if they are contractual and an employee doesn't follow those rules, then essentially it becomes a breach of contract issue as well. So it can somewhat strengthen your position. That being said, you don't have to make them contractual, but it can be helpful to say our disciplinary rules are contractual. It's your disciplinary procedure that should not be contractual. That would always be my advice, that your disciplinary procedure should not be contractual, because in making it contractual, you essentially then have to follow that procedure to the letter. So the procedure is what you would do when you're handling a disciplinary matter. So it's from investigation to conducting a hearing to the appeal stage and everything that follows as set out in your policy. You don't want that to be contractual, because essentially that does somewhat tie your hands to following that policy, those procedures in full. And if you don't follow them, then you run the risk of a breach of contract claim being imposed upon you. So my advice is always make it clear the contractual status of your disciplinary policy. There's nothing wrong with saying in the section that sets out your disciplinary rules that this section only will form part of your contract of employment. The remainder of the policy is non-contractual. That said, you can simply have your whole policy as non-contractual, and if someone breaks your disciplinary or breaches your disciplinary rules, you can still address that. But it's always an important point that I kind of reference when I'm drafting policies for clients, that you can make your rules contractual, and it somewhat strengthens your position when you're addressing those issues. I hope that answers your question.
Okay, thank you. Debbie's asked, in the event that the employee has been signed off sick, refused to attend occupational health appointment to see if they're fit enough to attend a management meeting, what legal steps do you have?
Yeah, so this is a really good point. I mean, for me, I always say being unwell to attend work and being unwell to attend a meeting are two very different things. So all you can do is offer alternatives. The employer says, I'm not able to attend that meeting. I mean, for example, if they've refused to attend occupational health, it's really important if we approach an employer and say we want to refer you to occupational health, that we explain to them that we believe it's in their interest to engage in that process, so that you can obtain up-to-date medical information, so that you can make decisions on how you can support them. That being said, we can't compel them to attend. So if they refuse to attend, we need to make it clear to them that if they don't engage in that process, then the company will have to make decisions based on the evidence it has available to them at that time. And that may be without the benefit of input from an OH assessment. What I then typically do, if an employee refuses to engage with an OH assessment, is I say to them, okay, if you're unwell to attend the meeting in the current format suggested, is there another format that we could offer that would enable you to engage in the process? It may be, for example, and I offer this quite clearly, I'm happy to engage with you in writing. You can make written submissions to me if I pose questions that I want answers to. So you can do that and offer that as an alternative. What I tend to do is, if someone refuses to meet with me, I'll say, look, I'm going to reschedule the meeting. Is there any other adjustments you want me to make that will enable you to attend? I tend to do that at least twice to show that I've been reasonable and tried to engage in the process. At the same time, I say to them, would you be prepared to engage in writing with me? But I do make clear to the employee, if they refuse to engage with me completely, then we're going to have to conduct the hearing potentially in their absence, and we're going to have to make decisions based on the evidence available to us, which will be without the benefit of their input potentially if they continue to refuse, and without the benefit of the input from an OH assessment. So that would be my advice. But I wouldn't certainly jump to holding the meeting in their absence early on. You would want to demonstrate you've been absolutely reasonable, given them opportunity to engage, offered alternatives to the process, etc.
Okay,
I hope
thank you.
that's your question.
Sellers asked, do you have to provide the full investigation notes, and can you admit names or statements where you feel it may be confidential, or if the witness has requested this?
The only time I redact information, and the first question is, you can look to redact information, but you need to have a justifiable reason why you're doing that. And the reason I say that is, in the interest of natural justice, you want to be able to give the employee, so the respondent, the person who is having to respond to allegations, we need to demonstrate we're giving them the opportunity to, be able to state their case and respond appropriately. So the problem with redaction, if we're redacting names, for example, the individual's likely to say, actually, how can I properly test the evidence if I don't know who's made allegations against me? It may be that that individual who's made a statement has had issues in our working relationship, and there's some kind of vendetta against me. So it gives rise to those sorts of issues. So I always say, only redact if you absolutely believe you need to, and there is a risk to someone's general well-being. It could be that someone feels that they're going to face reprisals for speaking up, for example, but it needs to be justifiable reasons. I certainly don't make blanket guarantees of confidentiality to witnesses. I say to them that I'm going to have to rely on this information. If it has to go to a disciplinary hearing, I will need to make evidence available to the individual. If it is absolutely required that you need to maintain confidentiality, then one of the things I always say is only redact absolutely what's necessary, or if you believe there is identifiable information throughout the document, you may have to summarise that evidence. But again, you would need to make notes as to why that piece of evidence has been redacted in the way it has, because you're going to want to potentially defend your position. My default position is I don't like redacting unless I absolutely have to. So just to make that clear, if you are dealing with that type of issue and you're uncertain how to proceed, seek advice from your HR department or any external provider you're working with. I hope that answers your question.
Thank you. So the next question, what about undisclosed disability brought up during a disciplinary? How do we handle those?
Well, if someone makes a disclosure during the disciplinary procedure that they have a disability, then I'm assuming they're making that disclosure because they believe that that disability is somehow going to either impact their ability to engage in the process, or they're using it as mitigation to dealing with certain issues. So I think, look, if someone makes it, they disclose that they have a disability that I've been previously unaware of, then I would essentially talk to them about that disability, ask them the purpose of them disclosing it now, ask whether they've disclosed it previously. It may be that you need to adjourn and check their personnel record to see whether any disclosures were ever made. If they're making a disclosure around a disability, then we need to proceed with caution potentially before making any decision on the outcome of the disciplinary procedure, because it may be they say, due to my disability, it has caused either maybe issues around misconduct if they have neurodiverse kind of challenges or disabilities. It may be that they say, actually, that's the reason why I behaved in the way that I have. And so it would be that you'd need to take that into consideration. If they make a disclosure at that stage, it may be that you need to adjourn and refer to occupational health to gain up-to-date medical information. But certainly you need to be mindful if someone says, I've got a disability, that we don't just dismiss that and say, we've not disclosed it before, therefore I'm not going to take that into account. It could be that there is mitigation in that, and you want to demonstrate that you've not been hasty to conclude the process and issue a sanction. So if you deal with that and you're unsure what to do, seek advice from your HR department. It's my absolute advice to you on that point. I see it happen a lot, so it's not unusual for it to happen. I hope that answers your question.
Melinda's asked, if during a grievance issues are upheld, for example, allegations of racism, does this have to be dealt with via a disciplinary as next steps? And
missed you, broke up a bit there, Joe. Did you say racism?
Yes. And does it have to be dealt with via a disciplinary as next steps? And do we have to do another investigation?
Well, look, if issues are, and I'm assuming, just read the question again, just so I can understand whether it's coming from the respondent.
Yeah, sorry. Melinda, if I don't read it correctly and you want to take yourself off mute, then that's fine. If during a grievance issues are upheld, for example, allegations of racism, does this have to be dealt with via a disciplinary as next steps? And do we have to do another investigation?
Well, I think if they're connected to the issue, if it's a separate issue, then you may need to consider investigating it separately and treating it as a separate issue. But if it's connected, you may have to make a decision about, do you kind of say, well, it's part of the process and we have to adjourn and do further investigation work. My point of view is you don't want to get sidetracked from the particular issues that you're dealing with that individual. So if they have a counterclaim, then it may be say, look, we need to deal with that either through, through the grievance procedure, for example. If they're saying, well, actually, I've been racially abused by a colleague, and this is the first time you're hearing about it, you may say, then are you raising grievance? I would suggest it would be treated as grievance. You would investigate accordingly, but treat it as a separate process. But it may be that if they're raising those issues as mitigation for whatever matter that you're dealing with, that you then have to make a decision about putting on hold the disciplinary hearing until you investigate the other issues, because it may be that mitigation is relevant and you want to take that into consideration. I hope that answers your question. I'm going to try and turn my sound's not very good, Joe, so I think it's me. But let's keep going. So if you've got any further questions on that point, let me know, though.
Yes, so we're raising it on the point that if somebody's raised a grievance because of racism against them, we've upheld that, and therefore the person who has been accused of the racism, we need to decide on next steps on how to deal with them.
Right. I can't hear you very well. Apologies. I think it might be my technical difficulty, but it sounds like you've had a grievance. That person has claimed that they have been the victim of racism. You've upheld, and now you're having to make decisions about what to do with the person who is essentially the perpetrator. Is that correct, Melinda?
Yeah, that's right.
Yeah, got you. Oh, okay, apologies. I've got you. So yeah, if you found that grievance is upheld and it's made out, the complaints are made out, then yes, what you would need to do is invite that person to a disciplinary hearing. But there's no need to do another investigation because your grievance investigation would be the evidence that you're going to rely on. Does that make sense?
Yeah, that's perfect. Thank you.
Yeah. So I would rely if you obviously if there's missing information, Melinda, that you need for the disciplinary hearing, then you go and do further investigation work. But if you've done a good investigation for the grievance, then that will be the information that you would rely on as evidence.
Okay, we can just link to your previous point though, because during the grievance, the person doesn't know who's raised the grievance. Now, if it's being upheld, if we go to disciplinary, we can.
So I mean, so it sounds like.
It.
Right, so the respondent in this case, the perpetrator of the racism or alleged racism, they're not aware that the complaint's been made against them.
They're aware, but they don't know who's raised it.
Oh, they don't know who's raised it.
Yes.
Right. Okay. I mean, I think you're going to have to make a judgment, Melinda, around making them aware of who the complainant is. Unless there's a justified reason for withholding that from them, it's going to be very difficult for them to be able to set out the case if they don't know who their accuser is, really, because maybe they say, I might have relevant information about my accuser if I knew who it was, that I would be discussing with you. It could be that there's challenges in the working relationship that might shape why the allegations have been made. So that's a point to consider.
Perfect, thank you.
You're welcome.
Isle has asked, if an employee fails to attend their scheduled disciplinary investigation meeting, what action can we take?
So if an employee fails to attend, did you say an investigation meeting?
Yes.
Yeah. So an employee fails to attend an investigation meeting, I'd follow up with them and ask them why. You have a right to meet with them. You have a right to ask questions. So, and it's an investigation meeting. You don't need to invite them into that meeting. You should simply go and find, if you've got someone sat in an office, somewhere you can go find that person at their desk and say, can you come with me, please? I want to have a discussion with you. So if you're inviting them, there's nothing wrong to invite them to attend the meeting. But if they are invited and they don't attend, we need to speak to them and ask why they didn't attend and then reschedule that meeting. And if they refuse to attend, then potentially that's a conduct issue. They shouldn't be refusing to attend meetings with you. So yeah, I would reschedule, but find out the reason why they didn't attend.
Okay, thank you. Sarah's asked, so what is the clear distinction in responsibility between an investigation manager and HR during the disciplinary procedure?
So HR's role is advisory. You're purely there unless you're leading the investigation, which can happen. If you're not leading the investigation, but you're acting as a background advisor to your, say, a line manager who's conducting the investigation, your role is to advise on employment law and matters of policy and procedure. The investigating officer is responsible for the conduct of the investigation, gathering evidence and making an assessment of what that evidence tells them. It is not the role of HR to influence any kind of findings on the part of the investigating officer. And then it's for the investigating officer to essentially set out thereafter whether there's a case to answer and whether it should go to a disciplinary hearing. And then the matter is referred to a disciplinary officer who is then responsible for making decisions about what to do next and whether sanctions need to be imposed, etc.
Thank you.
That's right.
Carol's asked, what would you advise if someone has been invited to an investigation meeting and refuses to attend and is leaving the business in a couple of days' time?
I would pull them into a meeting. I wouldn't invite, if I know someone's leaving, I don't invite them. I pull them into a meeting and say, you have a right to speak to them. They don't have a right to refuse. The challenge you've got, of course, is if they're leaving in a couple of days, they may think to themselves, actually, they're off sick. I see. If they're off sick, the challenge you'll have is that if they're off sick and they're not able to, they're saying they're unwell, the reality is their contract's going to come to an end. And at the point their contract comes to an end, you don't have, the kind of the employment relationship to rely on in terms of following your policies and procedures around conduct, for example. So if someone's refusing to attend a meeting unreasonably, it's a conduct issue. If they don't work for you anymore, you're not going to be able to rely on that. So it is a tricky issue. I hope that answers your question.
Right, okay. So I've got another one. It's quite a long one, this, Nathan. So
right.
just be careful. So Sarah's asked, an employee has had performance issues, for example, not bringing equipment in and following instructions, but they're in probation period. However, the probation was not upheld due to oversight from the manager and they were not confirmed in post. The employees assumed they have passed probation. What should HR advise the manager? can we extend her probation, or should we dismiss because they've also been, oops, things moved, could also been off, they've also been off sick and are off sick along with conduct issues, performance issues?
I mean, the challenge you've got with someone who's currently off sick in their probation period is that ordinarily you would look to, terminate employment during probation, and do that relatively quickly. If obviously they're off sick, you are going to need to take into consideration what is the reason for absence, because it may be attributed to a disability, and that obviously is what I would call an exceptional circumstance that I would want to risk assess before making a decision to treat that person as a short service dismissal. I.e., we're not going to follow a process. We're going to bring them into a meeting. We're going to terminate their employment, make a payment in lieu of notice, and get them off our books. If there is an exceptional circumstance such as a potential disability, they're alleging whistleblowing, they've raised a grievance, for example, they've alleged that they've raised health and safety concerns. These are all potential issues that could give rise to a claim whereby you don't need qualifying employment to bring that claim. So my view would be, if you've got somebody off sick in their probation period, you would want to look to extend. I certainly would find it reasonable that you extend the probation period by the total amount of time that they've been absent from work, because that's the amount of time that you've not been able to assess their suitability for role. But you'd then want to make sure that, any extension, you monitor their suitability for that role, and if they're not working out, you bring their employment to an end. But if their sickness absence is for a routine issue, then it's likely that the risk is going to be very low. But you need to pay close attention to the reason for sickness absence to take that into account. But my advice would be that if a decision's been made, not that someone's employment should be terminated in the probation period, it's really important that the line manager tells the employee kind of there and then, essentially, in that final review meeting, whenever that may be held, so that the employee isn't under the impression that their probation has been passed when it's not, if that makes sense. So I hope that answers your question.
Jess has asked, is it possible to use the fact-finding report for a disciplinary meeting, or the fact-finding report guides HR to start an investigation, as the person in question has resigned and has 3 weeks left?
Well, is the person that's resigned the respondent in the matter?
Jess, are you able to come off mute and just clarify that?
Yes, okay. If the respondent to the allegations has left the business, then there's going to be very little that you can do, because they've left. So there's no one to take disciplinary action against, because they no longer work for you. But in response to your question, if you've got an investigation report that's been produced, so is that second question? Yeah. If you've got an investigation report that's been produced as part of an investigation, then yes, you would want to rely on that investigation report at the disciplinary hearing and carry that forward, so that the disciplinary officer can review the evidence gathered, so they can make decisions on an informed basis about what to do next. I've got time for a couple more, Jo.
Yeah, okay. If an employee leaves during the investigation period leading up to a gross misconduct disciplinary hearing, should this be noted on any future reference requests or not, because no final decision was made?
Yeah, you can. I mean, there's nothing wrong with giving a factual reference. And in fact, if it's factually correct, the employee left pending disciplinary, either pending a disciplinary process or disciplinary action, you could look to include that in a reference. I mean, the only thing I'm always mindful of is that you are potentially going to impact that person's ability to gain alternative employment. So the only time I might consider doing that is if you're working in a regulated sector, so like education, whereby you may be duty bound to make certain disclosures in a reference. But I would always make a judgment around, what's the reason for making that disclosure. But if you think it's relevant, then yes, you can provide a factual reference that does state that the person resigned pending disciplinary action or disciplinary process. The only time a reference becomes problematic is if we're making statements that are untrue, essentially, or not factually correct. So you would want to be very factually correct in what you're saying.
Okay. Jess has asked 2 questions, Nathan, so I'll just break it down. In a hypothetical scenario, the investigating manager isn't fully present in the role, i.e. completing a report, however, to a poor standard. How far does the advisory role of HR go?
Well, you as an HR advisor, I would suggest that you would meet with that person and say that the report has fallen short of the expected standards, and get them to go back and do the investigation work that's required. So you're not influencing or shaping decision making or findings, but you're saying to them the report is not sufficient. Can you please go and make findings? Because the alternative would be is you allow it to go to a disciplinary officer, who is likely to then kick it back to the investigating officer to say, I've got insufficient evidence or information to be able to make an informed decision. But there's nothing wrong if you're advising purely on the process. If the report doesn't have all the relevant information, that you say to them, look, this report's got missing information, you need to go back and investigate, because what you're doing is ensuring that the respondent has has access to a fair hearing that's going to be based on good quality evidence. I've got time for one more, Jay, before I...
Okay. Well, Abigail's got a question. So what I'll do is, if there's anyone else puts anything into the chat, including your question, Abigail, I'll email them to Nathan, and then when I get the answers, I'll come back to you, if that's okay. So we'll just do the second of Jess's question. What would be the more important, the speed at which a disciplinary process is completed, or the thoroughness of the process? Thinking in terms of the impact of the person under the Investigations Wellbeing Act. Etc.
Yeah, every process you follow, guys, needs to be time bound. So if there are delays, they need to be justifiable, and there should only be delays that are proportionate to either the investigation process or the disciplinary process. I mean, the disciplinary process itself should be straightforward. It's typically an investigation that will take time. An investigation should not be rushed. It should be as thorough as required in order to allow the investigating officer to establish facts around the matter that is under investigation. Once that process is concluded, they should draft a thorough investigation outcome report, and that should be passed to a relevant disciplinary officer for consideration if it's considered that necessary. But you should always focus on thoroughness of an investigation, and any procedure that you follow thereafter. We should be time bound, but it should be, the process needs to be as long as it needs to be in order for you to demonstrate that you followed a reasonable process and procedure in the circumstances. I hope that answers your question, but yeah.
Thanks, Nathan. So, like I say, Abigail, your question, there's another one just come up. I'll email them to Nathan, and then I'll come back to you with the answers.
Yeah, perfect.
I'll send some correspondence out to everyone that signed up for the event this afternoon, and I'll put a post on LinkedIn. So if you'd like a copy of the follow-up information or the recording, then please put a comment against the LinkedIn post. Our next event is on Tuesday, the 30th of June, and is called How to Recognise Imposter Syndrome. A link to sign up for that will be included in the email. If anyone's recruiting, we've also got FD Recruit, Exec Recruit and Charity Recruit within the group. But otherwise, I'd just like to say a massive thanks to you, Nathan, for your time and effort in putting the event together, and for everyone for turning up. Thanks very much.